Hello and welcome to this discussion, which is hosted by the Observer Research Foundation on exploring global perspectives on refugee protection frameworks. According to the United Nations, one in every 95 people on earth has fled their home as a result of conflict or persecution. And by the end of 2020, there were 82.4 million people in the world who were forcibly displaced and 26.4 million refugees. The scale of global displacement and forced migration is likely to keep increasing as new political, social, economic, and environmental challenges emerged in a globalized world, made more so by the pandemic. The recent situation in Afghanistan is a reminder that this crisis is here to stay. And yet, most countries do not have an adequate refugee protection regime or legislative frameworks in place. This is especially true of developing countries, which host 86% of refugees in the world. The 1951 Refugee Convention, a treaty by the United Nations, has been adopted as the universal framework of refugee protection. Many countries, including India, are not signatory to it. The 1951 Refugee Convention has recently completed 70 years of existence, and that brings us to some crucial questions on its relevance as well as its limitations. Can the 1951 Refugee Convention address the changing social and political realities of today? How can the universal approach to refugees address the issue of local geographies? We will be analyzing some of these questions over the course of the next hour and a half with an excellent panel of speakers that we have assembled from around the world. Please allow me to introduce them. Manoj Kumar Sinha is director at Indian Law Institute. Emily Venturi is non resident Academy Associate at the Royal Institute of International Affairs at Chatham House, London. George Mapidi is Professor and Deputy Vice Chancellor at the University of Johannesburg in South Africa. Waid Al Shobaki is Assistant Professor at Department of Public Administration at the University of Jordan. And K.M. Parivalan is Associate Professor and Chairperson at the Center for Statelessness and Refugee Studies, School of Law, Tata Institute of Social Sciences in Mumbai. And finally, Anasua Basu Chaudhury is Senior Fellow at Observer Research Foundation. Thank you very much for sparing your time to join us for this discussion, which we will be holding in two parts. In the first part, we will invite each of our speakers to offer opening remarks before we open it up further to questions. I'd like to start by inviting my colleague Anasua, who is the author of a volume that has recently been published on revisiting the 1951 Refugee Convention. Anasua, the floor is yours.
Thank you so much, Sunana. Good afternoon and good morning to all of you. And as the editor of this ORF GP series, it's my pleasure to introduce the volume for today's discussion. At the very outset, let me take this opportunity to thank all the contributors for their patience, for their cooperation, and of course for their contributions. Well, the volume entitled Revisiting the 1951 Refugee Convention, Exploring Global Perspective, talks about the relevance of 1951 Convention relating to the status of refugees in today's globalized world. As we all know, that 1951 Convention was the first comprehensive attempt to define refugees and also charted a detailed guideline for host countries to ensure adequate protection and preservation of the rights for all refugees. And of course, it was approved at a special United Nations conference held on 28 July 1951 and consolidated previous international instruments, legal instruments relating to refugees. The 1951 Convention is a rights-based legal institution, a legal instrument associated with three basic principles: principle of non-refoulement, non-discrimination, and non-penalization. But initially, it is limited to its temporal and spatial scope, as it covered the period before 1st January 1951 and confined its mandate to the European refugees only. We all know that later 1967 protocol related to the status of refugees expanded the scope of 1951 convention by making it a relevant international legal regime for addressing the contemporary global refugee crisis. Now, we all see how in globalized world, thousands and thousands of people, they migrate every day from one place to another, from one country to another country, of course, in some point of time without valid, documents. Refugees, stateless persons, and asylum seekers are seeking refuge in other safer countries, and economic migrants, more especially, are looking for greener pastures elsewhere. In these emerging situation, it is it has often been argued that the existing international and regional legal mechanisms for refugees may appear to be insufficient, ineffective, and even partially redundant in an evolving neoliberal economic order facing the Westphalian state system and sovereignty. The 1951 convention was primarily a mechanism for the post-war European situation that ignored the future concerns of decolonized states. Therefore, it now remains how far the existing international legal ecosystem can address the global South's concerns without having a pluriversal and decolonial approach to the contemporary refugee issue, moving beyond the Eurocentric 1951 convention, because it is important to understand, as Sunana in her initial comment, she specified that South Asian countries are not signatories to the 1951 convention. So in this context, this is very important issue. So as new political, social, economic, developmental, and environmental challenges emerge in an increasingly globalized world, the process of refugee creation has increased also manifold. In 2021, the convention marked its 70th year of coming into existence. People, institutions, countries have debated the relevance and limitations of the conventions over the years, with criticism of its diminishing impact and also applications. In fact, it's noteworthy in this particular context to quote the UN High Commissioner for Refugees, Filippo Grandi, where Grandi has said on occasion of the 70th anniversary of the convention that the convention continues to protect the rights of refugees across the globe, and that millions of lives have been saved because of it. But at the same time, it's very interesting to note here that at the same time, Grandi also expressed concern about the recent attempts by some governments to disregard or circumvent the convention's principles. Taking cue from this expression, it can be attributed to allegations that some developed nations have flouted the norms set by the convention, and in this regard, definitely attentions are going to Australia or the United States. In fact, in recent years, the Syrian refugee crisis actually has captured global attention due to the number of asylum seekers, and also so far as the inhuman condition of their journey is concerned. So this has propelled political discourse on the precarious situation of refugees, as well as on the rising fear among the native population in in destination countries, regarding the fear of security and also demographic changes. Uh, at the same time, the question become important to raise here is, has the definition of a refugee failed to stand the rest of the test of time? This is a very important question here, and that's why we intend in this volume to pose this question for further discussion, because we know the definition of refugee has been going through a kind of changes through 1967 protocol, the OAU convention, the Cartagena declaration of refugees. So with these few words in this volume, we actually intend to raise several other questions, more precisely two questions. First, do the definition and frameworks set forth by 1951 convention encapsulate the socio-political realities of the 21st century? And the second question that we intended to find suitable answer is, to what extent can the universal mechanisms of refugee protection address the issues of local geographies? Uh, you know, with these objectives in mind, the entire volume has been divided into three segments. The first one has been devoted on understanding the relevance of the 1951 convention, the second one on refugee protections and local geographies, and the third one is, of course, on precarities of stateless people. And we have, included different geographical locale cutting across South Asia, Middle East, Africa, Europe, and Australia, just to understand how different parts of the world at this moment think of the relevance of 1951 convention. With these words, I'll stop here. And as we have a galaxy of experts to discuss on these issues, so I'll be looking forward to hearing to the speakers. Over to you, Sunana.
Thank you, Anasua. You have raised a lot of questions and really set us up to questions that we would like to interrogate further in the discussion. Also, congratulations on a very comprehensive and detailed volume that you have brought up, of course, with the help of many contributors who have joined us today. I would like to turn to Dr. Sinha and ask him, building on what Anasua has just said, what are the major challenges in refugee protection that the world is grappling with?
So thank you very much, Sunaina, and excellent overview of Anasua about the book and also the refugee situation globally, and particularly what we have to do. And even if I take certain points from you, which you have in your presentation mentioned a little bit, uh, how we addressing whether we need to become the party of the 1951 convention, state. And classic example in South Asian countries, most of the countries except one or two are not parties of the 1951 convention, but the large number of refugees, if I apply with the Indian scenario, we see is starting from 1947. After the independence, around 5 million from both across the border people moved, and they were somehow settled in India, somewhere settled in the Pakistan also. Then we have again 1959, a large movement of people from Tibetan people, they entered in India, and they have been living peacefully. Their status, they integrated more or less in this society. And we are very happy to share with the international audience also that certain rights which the Tibetans were given, like citizenship in the 2010 by the Delhi High Court. So High Court has looked into that particular case and considered granting of nationality to one girl. She approached the Delhi High Court, and that case has led to the 30,000 Tibetans became entitled to get the Indian citizenship. And also in 2013 or 14, first time they voted in the general election of the India. This is one we see the judiciary part. So when we into the enforcement angle, that is the major channel, whether it's a international human rights law, international refugee law, or even international criminal law, it ultimately comes down to the enforcement. Enforcement remains a big challenge, whether a state is party or a state is not party. Even if you become party of any treaty, Vienna Convention of Law of the treaty will be implemented in good faith under Article 26. So, like, no, so implementation of treaty is good faith. So there is a less kind of coercion or compulsion at the international bodies to implement the treaty. So ultimately, the primacy of the national judicial system has to be strengthened and has been also duly recognized in all the international human rights instruments and also in the refugees. If we look into the jurisprudence of the refugees, protection of the refugees, it's no recognition has been done by the UNHCR and status has been granted. But when it comes to the dispute, when it comes to the rights, we found that, and even to stay the deportation order, it's a strong jurisprudence has been developed through the Canada, Australia, New Zealand, UK, and USA. In one sense, there are a number of terms have been also membership of a particular social group. If you look into that, has been how women has been protected. So definitional gap has been addressed by the jurisprudential aspect, like, whether women is protected. Islam versus UK, if you look into the case where it's like, no, women has been protected, but women is not part of the definition. Who falls under the membership of a particular social group has been defined or elaborated by the judicial system of the various countries. So we see a gap which exists in the system has effectively addressed by the local system, by the local judicial system. And for all the countries, like, our focus is in your presentation, which you have mentioned correctly, that 86% of the refugee populations are in the developing nations, and particularly in the southern part, like, south. Uh, so, like, so large number. So we have to look into that particular mechanism. And then in that context, if I come back to the India, so we see that we have a this question always attracted academicians, even in the UNHCR offices. The India should become party to the 1951s. On many occasions, the head of the UNHCR, we also, like, Anasua and others, we participated. They said, since India is protecting refugees, very liberal approach in accommodating in some way, I'll not say always, but some ways, very liberal approach we follow in accommodating the refugees. So what's the harm if India become party? If you become a party of the 1951 Convention and 1967 Protocol, that may allow to seek more financial assistance from the international organization and so you are doing. So they say you are doing. Why you are hesitant? So, but if you look into the governmental perspective, they always say it's now old, it has lost its relevance. So we go back to the historical context. So when we have to attack, when as an authority I have to attack, we go back to the historical context and see this convention has not been taken note of the countries which got, like, independence after 50 onwards, or even at time of drafting of this convention. So it has left, and it's more like a Western concern, and Western people were involved in heavily, and they thought about is a temporary. In fact, like, 1951 convention and idea was also it's a temporary phenomenon. It's not going to long for the refugees, a temporary phenomena, and it started because the First World War and Second War. So some way the foundation which we like, created a building, we realized we have to keep the people for 3 years or 4 years, but after 1956 or something. So then entire, like, gradually we started, even international community started realizing, no, the refugee problem is going to stay and it's a permanent. And then, like, also the mandate of UNHCR has been permanently, after many years, that has been made a permanent. Otherwise, it was always a new. So you see the somewhere foundational also, we started with it temporary. We never thought, like, those who were part of it, they never thought this problem will remain permanent. And somewhere the states, like, has, as Anasua has mentioned, very jealous about the sovereignty. When we talk about the sovereignty, they want to take care of their own people. They have a political commitment, they have a political vote, there are a lot of factors. They don't want to, like, share. So state and even some extent people, both, they, like, some changes, they struggle for the, like, their own survival. They say, we have our own problem, now you additional population. So even people from Rohingyas, they are coming to India. So there's a great resistance, very strong resistance from the some sections of the society, they forget, they are like, they have a genuine fear of persecution, and that they have to be accommodated. If I take you back to the 2015 and 2016, when like even 2012 and 2015 also number of Rohingyas entered, so it remained a focus of political discourse and also subject of judicial scrutiny. A case has been also filed in the Salimullah versus Union of India in the 2017. The case is also pending there. And the idea, and this is the they fear maybe government will deport all of them out of deportation, and that to stay. So this case is filed by some public spirited individuals. Interestingly, there are a number of facts, those who had an opportunity to access the details in that particular case. Government in the principle of non-reforma, which say there's no ambiguity, there's no doubt that principle of non-reforma has acquired the status of just cogence. So this question was also brought before in the court, where our government stand, that since we are not party of the 1951 convention, Article 33 doesn't apply to us, and some way we manage, or some way we have been, state is arguing on that the principle of just cogence is not applicable to us, because so it's a different interpretation is there. So we see that so even the principle of non-reforma becomes subject of great debate between the state, public, experts, which should not be there, because that's a firmly established just cogence, a higher norms, a peremptory norm. It has to be respected, and it has to be seen known in the context of the 1951 convention. It has to be evaluated in the context of the asylum seekers. You don't go for the second stage. So asylum, when we look into the UN Declaration on Territorial Asylum 1967, it says the two things: shelter and effective protection. So what, first we have to think about the shelter to the persons who have a fear of persecution. The state will come the later on, and effective protection if a state has to provide. So the moment let the people come, and that has to also, so the principle of non-reforma is not only since it's mentioned under Article 33, but it's very much inherent under the Article 14 of the Universal Declaration of Human Rights. If I put you, even other articles of the ICCPR, other instruments also, so which says the right to seek and enjoy asylum is fundamental, rights, which, so that has to be viewed and that has to be respected. But there are a lot of factors, local factors, which also play, which govern some way. And there, what I feel, whether we become a party, whether we redesign the 1951 convention, whether these initiative will completely remove the existing problem, that is the question we have to find out. I have a certain doubt, even if we expand the definition of 1951 convention, it's not going to help, because ultimately it comes to the state. Once refugee entered, it's international mechanism is there, which is somewhere even illegally is a guidance, some kind of, ultimately what kind of system you have in place. And that system, what I see, whether your state believes in the rule of law, what kind of constitutional protection or bill of rights you have. If a bill of rights consists of equal protection to the citizen and equality before the law to the citizen and non-citizen, whether right to life applies to the citizen and non-citizen, if that is there. So constitutional guarantees, I mean, if you have, then rule of law, if you have believed, then you have independence of judiciary. Whether judiciary is not, so Indian judiciary, in that count, I say, we are very proud that Indian judiciary is not discussing and debating and engaging themselves in the more niceties of the signature, ratification, reservation. This
That's
they look.
right. Thank you so much, Dr. Sinha. You've actually you raised some points that we definitely have to get back to, including whether we should be thinking of redesigning the 1951 convention, or is there any need for that. I would like to invite Professor Mapidi to give us the perspective from Africa and the major challenges that exist there in refugee protection.
Thank you very much, colleague. Good morning, good afternoon, colleagues. My initial remarks this morning, this afternoon, we'll cover some legal protection mechanisms for refugees that you find on the African continent, and also a few challenges that we are seeing or we are experiencing. And I was listening carefully to the remarks of Dr. Sinha, and some of these are really linked. Africa, colleagues, has about 54 countries, and it's both a refugee producing continent but also a refugee hosting continent. And often you see the pictures of people on boats trying to get to Europe, and creates an impression that all the refugees from the continent are in Europe, but Africa hosts the majority of the refugees that are generated here, and also from elsewhere outside of the continent. The legal protection mechanisms that you find on the continent can be divided into three. Firstly, you get your international refugee law and standards. And Anasua earlier talked about, and Dr. Sinha, about the Convention of 1951 and the protocol. But on the continent, we also have some regional and the so-called refugee laws. But let me go back to the 1951 convention. Despite having 54 countries, only 48 African countries have acceded to this conference. It's not everyone, but it's the majority. And the second part of these legal protection mechanisms can be found in the regional refugee laws and standards. And the OAU, Organization of African Unity Convention, is one of the well-known ones that colleague Anasua already referred to. And this has been signed and ratified by 46 African Union members, not all, again. And the importance of this is that this convention was conceived to render international refugee legislation applicable to the African context and reflect the African circumstances and values around refugee protection. So it supplements the 1951 convention. I think something that must be emphasized. The last part of these legal mechanisms is the national refugee laws and policies. And this issue was already touched on, and now I'm bringing the African part or side of things. These laws that deal with refugee issues on the African continent play an important role in extending and imposing obligations to refugees at national level. Obviously, you have those regional, those international instruments, but you need laws at national level to impose rights and all that. And they're generally passed by parliament. They take the form of acts of parliament. And often you find that their constitution that amplifies these rights. You take countries such as South Africa, you take countries such as Kenya, Ghana, Namibia. There are perfect examples that have basic rights or Bill of Rights, as mentioned by Dr. Sinha, which are important to elevate this. But now, the problem with all this is that you also have countries that do not have any refugee laws, which is a problem. A study conducted in 2019 established that 46 African countries had national refugee laws. It's a high number, but in reality, given the refugee problem, you would expect every country to have this kind of laws. Another thing, there's a difference between having laws on statute books and having laws applied in practice. That is one important thing that I hope we'll touch on later. So quickly on the gaps and challenges, I'll highlight a few. The first one, colleagues, that I need to highlight this morning or this afternoon is that it is commonly known that the full and effective implementation of the international and regional instruments remain elusive in many countries. These provisions are there in the international instruments, but in practice, as I've said, it's a different story. Secondly, there are classes of refugees, for example, climate refugees and economic refugees that are a reality today that are not meaningfully provided for in the applicable legal frameworks. But colleagues, allow me to highlight one important point which has been also covered by several commentators, that the key issue here is that these frameworks tend to focus more on human-made refugee challenges, which are still relevant today, but there is more. And as a result, they neglect those natural causes where we're talking about global warming and all this. We hear that future wars will be fought over fresh water. So the question is, what are we doing to prepare for those? That said, there are those that believe, and I'm one of them, that the definition of refugee as per the OAU convention is deemed to be broad enough to extend protection to victims of natural disasters as well, because of how it has been drafted. The third challenge, or what one would call a gap, is that refugees are a diverse group of vulnerable persons. There is a perception that this is just a harmonious or homogeneous group, but they are not. They consist of a variety of groups and categories of persons that cannot be adequately protected with a one-size-fits-all approach. You've got children, you've got vulnerable women. At the moment, there's another challenge of the LGBTQT plus, or whatever acronym you use, community. We know how hostile many African countries are to these communities. Imagine you're a refugee and you fall in this group. It's also another challenge where protection might not be adequate. Furthermore, refugees experience widespread human rights deficits. Not every country protects their rights, human rights, they vary. And then this situation, in my view, is exacerbated by, among others, a lack of resources and nationalistic sentiments prevalent in many African countries that lead to xenophobic attacks and so on. Now, in my view, African countries need to advance refugee rights, and they need to find long-term solutions to forced migration, because dealing with refugees when they arrive, it's secondary. We need to address the problem, prevent it from arising early on. The principles of good governance, namely accountability, transparency, openness, efficiency, and efficacy, the rule of law, Dr. Kumar talked about, Sinha talked about it, and popular participation in decision-making process, it's important. We know what dictatorships, are doing on the continent and all this. Furthermore, we need to eliminate, or African countries need to eliminate and combat all forms of ethnic, racial, religious, and ideological divisions, adhere to democratic principles, refrain from interfering in the internal affairs of other countries, and make efforts to create a climate of peace and stability. In the end, the best solution to the refugee problem, in my opinion, is to prevent and or address the conditions and issues that force people to flee their home countries. I will pause there, and I'm looking forward to engaging with colleagues. Thanks, Sunaina.
Thank you, Professor Mapedi. And so many things that you said, including the fact that not just Africa, but the world has to think of not just advancing the rights of refugees, but also preventing it from occurring. I'd like to turn to Emily now and ask Emily. You have analyzed how migration and asylum policies in Europe have been shaped by the question of securitization. Can you shed some light on that, and also what has aggravated this in the last few years?
Good afternoon to everyone, and really thank you, Sunaina, for moderating, and a special thank you also to Anasua for organizing the volume and bringing together this truly fantastic panel that it's a pleasure to be a part of. So yes, in my research, what I've been looking at is the role that security has played in European political rhetoric, as well as policy decisions on migration and asylum. And it's, I think, of particular note for how we think about the application of the 70th anniversary of the Refugee Convention in Europe. Russia's invasion of Ukraine this morning as well really recenters issues of human rights and displacement in Europe. And so it's a particularly delicate and worrying time to be thinking about these issues in Europe right now. Maybe to start us off, what I'll do is actually share an anecdote, because I think it's helpful to look at how these sort of big policy and issues play out in political rhetoric every day in Europe. So in August 2021, following the Taliban takeover in Afghanistan, French President Emmanuel Macron controversially stated that Europe should protect itself from irregular migratory flows from Afghanistan. We see this statement to be highly concerning because firstly, most Afghans are not hosted in Europe, but are actually internally displaced or hosted by neighboring countries. And it shows the tendency of European political leaders to blur the line between migrants and refugees when many Afghans have a strong asylum case, according to the 1951 Convention, but are treated from a security and a migration perspective from European political leaders. So when we look at the application of the Refugee Convention in Europe, a trend that emerges really is of increasing efforts to move asylum outside of Europe's borders in the name of security. And this process of securitization is sort of referred to in international relations theory as a process through which political actors attach a national security value to policy choices that are unrelated to security. And we can see that in Europe, this has really escalated since 2015, when many far-right parties built their political fortunes in Europe on anti-immigration campaigns. And countries stepped up their border policies and their efforts to externalize asylum, giving rise to what is usually colloquially referred to as Fortress Europe. And this has occurred despite the fact that Europe hosts less than 10% of the world's refugees. So to look at how security and securitization of asylum and migration poses a challenge to the application of the Refugee Convention in Europe, we can look at 3 examples briefly. Firstly, the criminalization of search and rescue operations in Italy. Secondly, the pushback of migrants and asylum seekers in Greece. And lastly, a broader reflection on broader European Union level policies for externalization in the name of security. So if we start briefly looking at Italy in the Mediterranean, which unfortunately has become one of the deadliest migrant and refugee sea crossings in the world, search and rescue operations initially started off in 2014 and 2015 as nationally led humanitarian approaches by national coast guards. But quickly, due to high costs that were unable to be maintained by countries such as Italy and Greece, as well as the souring of national public opinion with the rise of anti-immigration sentiment, these efforts were stopped. And we moved more to a centralized border management system by the European Union agency Frontex, which is the European Border and Coast Guard Agency. This resulted in an increase in border control rather than search and rescue, an increase in agreements with countries such as Libya, who are sort of highly criticized by the international community for human rights violations against migrants and refugees, as well as the criminalization of nonprofit organizations, which stepped in to conduct civic-led search and rescue operations. And so in 2019, Italy's Interior Minister Matteo Salvini passed an emergency decree that effectively implemented sanctions against NGOs and individuals aiding irregular migration to Italy. It imposed fines on NGO search and rescue vessels, threats to revoke or suspend their licenses, refusal to disembark in Italian ports, which led to a variety of standoffs and subsequent fights, some of which are still ongoing in Italian courts. And so this is a very practical example of what the implementation of security-based approaches in Europe is leading to. Looking ahead, it's critical to refocus on humanitarianism within search and rescue operations in countries such as Italy. Revision of legislation is necessary at the national level. Support for investigations and accountability mechanisms is necessary, as well as a renewed relationship between civil society in Europe and national authorities. If we move east towards Greece, what we see is an increasing use of pushbacks. And we awoke to tragic news a couple of days ago to the death of 12 migrants and asylum seekers at the Greek-Turkey border, with both the Greek government and the Turkish government reciprocally placing blame on the other country. And really sort of not focusing on the key issue at hand, which was the violation of human rights and the persistent use of pushbacks in Greece. Pushbacks, it's a non-legal term that has really sort of been used a lot recently in European politics, and it refers to when a person is apprehended after an irregular border crossing and immediately sent back to a neighboring country without an individual assessment of his or her asylum claim. So in the case of asylum seekers, indiscriminate pushbacks is a blatant violation of the right to seek asylum in another country, irrespective of travel modality. And we've seen pushbacks occur in Greece, both at its land borders, particularly in Evros, as well as in the Aegean Islands by sea. And the European Council on Refugees and Exiles has described this practice as the frontline tool for Greece's migration policies and the first option in Greece in order to halt the flows of refugees and deter others. International organizations and civil society have responded. The IOM, UNHCR, and the European Parliament have all called for urgent investigations in Greece on the use of pushbacks, although this has not occurred yet, and increased pressure is necessary to make sure that investigations do take place and that accountability measures are put in place, especially in Greece, but across other European borders where we see these practices continuously pop up. And a last reflection, zooming out on broader European Union externalization policies. While asylum and migration are considered national sovereignty issues and are a competence of national governments, this is a policy area where competencies are shared with the European Union. And after 2015, migration increasingly became a leading issue for European Union voters, and therefore the European Union increasingly engaged at an institutional level on the issue. Even though, following the Syrian crisis, the pressures on Europe were much lower compared to neighboring countries such as Jordan, Lebanon, and Turkey. But nevertheless, immigration and asylum rose to the top of European Union political agendas with consequences on policy as a result. So some of because of the lack of consensus in Brussels among European states as to how to set up responsibility sharing arrangements across the European Union to host refugees. What we've seen is an increasing push to externalize asylum and an increasing push to establish agreements with neighboring countries to effectively keep refugees and migrants outside of Europe and close European borders. So a primary example of this is the 2016 EU-Turkey deal, according to which Turkey agreed to close its borders with Greece and host returnees who had entered Europe irregularly, in exchange for European concessions that included a large funding package, some very limited resettlement quotas for refugees, as well as a lessening of visa restrictions for Turkish citizens traveling to Europe. The implications are still ongoing today because this deal effectively enables Greece to return to Turkey anyone who has entered Europe irregularly without already having gone a formal asylum application process. And it also has, from a foreign policy perspective, has placed the European Union on the back foot when engaging with the Turkish government, because migration and asylum are consistently a bargaining chip between Turkey and the European Union, with Europe depending on Turkey to keep its borders sealed. We also see a set of other agreements that the European Union has put in place with countries, particularly in the Horn of Africa, North Africa, and the Sahel, in a stated effort to tackle root causes of migration, usually linking development funding to migration control objectives. These agreements have been heavily criticized for a Eurocentric top-down approach to project design, for an excessive focus on repatriations and border control, and really on sort of the risk of centralizing short-term border control managements within much broader foreign relations with Europe's neighboring countries. So what can we take away from this? Well, we can say that securitization has really had significant consequences on how European countries and the broader European Union approach asylum at the 70th anniversary of the Refugee Convention. We see very worrying trends of European Union countries pushing asylum and migration issues outside of Europe, even though Europe as a continent does not host the majority of refugees at all worldwide. When we think about the Refugee Convention, what also emerges from the European case is a lack and a vacuum of accountability mechanisms for a violation of international law at Europe's borders. We see this in the case of pushbacks in Greece, as well as in the case of criminalization of search and rescue operations in the Mediterranean. So the current European context also reignites debates about the need to establish independent monitoring mechanisms for the implementation of the Refugee Convention. And finally, what it also shows is that European public opinion, unfortunately, continues to consistently play an influential role on how European Union policymakers address the issues of asylum and migration. And so European governments really have critical responsibility and need to cultivate public support and educate public support for rights-based approaches to asylum. especially as we mark the 70th anniversary of the Refugee Convention. So I'll end my remarks there, and very happy to continue the discussion comparatively across regions throughout the panel. Thank you so much.
Thank you, Emily. As you also said, much of the international discourse seems to emphasize as if the West and Europe, for instance, hosts the refugees, the majority of the refugees of the world, but it really is neighboring countries, as Professor Mapedi also brought out in his remarks. I'd like to turn to Professor Dr. Parivalan now, and get the perspective from South Asia. Emily, of course, talked about the security-based approach to refugees, which we see in Europe. We are seeing some of that also now in South Asia, the othering of refugees from an attitude of accommodation and we are now moving to a perspective of national security and not seeing it as a human rights problem, something that you have spent some time thinking about. Can you tell us about that?
Yeah, thank you very much. At the outset, my greetings to everyone here, the panelists, Dr. Sunaina, Dr. Anasua. Thank you for hosting and inviting this important consultation based on the recent edited volume by Dr. Anasua. Well, to share a few thoughts initially on how we look at from the South Asian perspective, and I will connect also more from the Sri Lankan refugee perspective, which we have been working very closely in the recent times. As it has been highlighted by Professor Sinha earlier and Professor Mapedi and Ms. Emily, as well as the introductory part of it, that we have a context where the conflicts, human rights violations, persecutions, are on the increase, almost leading to that 80 to 83 million plus people being forcefully displaced as a matter of concern. And has already been highlighted, the ongoing tension, Russia-Ukraine, or the Armenia-Azerbaijan earlier, or the takeover of Taliban in Afghanistan in South Asian region, or the tensions which have been going on in Myanmar in Southeast Asia, which connects to South Asia as well. The refugees largely pouring into Bangladesh, and some of them trickle into India. The Rohingyas India is also a matter of debate, which I'll bring in. So now, to start with, this being the context that there is an ongoing displacement, ongoing forced migration, victims, which is on the increase. We are also trying to look at how largely the 1951 Convention and 61 Protocol are relevant in the contemporary times of globalization, contemporary times of ongoing interstate crisis, as a context we have. And definitely it lays the foundation. The 1951 Convention, from a South Asian perspective, still remains, even though except Afghanistan, none of the countries have signed it. It remains one of the most important instrument, to get the legal definition or the non-refoulement principle, non-discrimination element of it, all that been highlighted earlier. 1951 Convention remains the most relevant legal framework. Now, looking at from South Asian perspective, most of the countries have not signed or ratified it, except Afghanistan, which is of no relevance because Afghanistan does not host refugees, rather it generates. So that also becomes not so relevant. But some of the countries which are hosting high in numbers, for example, Pakistan, for example, or the Bangladesh, or India, we have to, look at from the perspective that, if not signing and ratifying, a point being made by Professor Sinha as well, that probably 1951 Convention was earlier called as Eurocentric, then later 1967 protocol brings in a clarity that it has been geographical limitations are removed. But yet, if you're calling it outdated, now my one question to place here is that can we revisit it? Can we revisit the 1951 convention and update it in the context that today the nature of conflicts are also changing. There are climate-related displacements which are emerging, and these all have to be probably done. So this is one point that I'm just flagging that we have to do. Number one. Number two, we are all aware that besides the the convention and the protocol, there is also regeneration being made with the recent New York Declaration and the relevant global refugee compacts or the global compacts for refugees and migrants, which are very significant in terms of regeneration from a South Asian perspective. And of course, the SDGs, the Millennium Development Goals and Sustainable Development Goals of leaving no one behind brings a reminder that we need to contextualize the 51 Convention elements, and we need to continue to apply the notions of empathy, compassion, responsibility sharing, and so on and so forth becomes very relevant to South Asia when none of the countries are ready to sign it per se. So one is the improvisation, revisit improvisation, and then seeing whether it's relevant one. Or the most important aspect which we see is that the practical aspect we see is that probably developing a national legislation makes it more relevant, or even the regional one. A regional one was mooted, of course, earlier and pushed into the back burner under the aegis of the South Asian Association for Regional Cooperation. But still, the national legislation on refugee protection, national legislation on statelessness, national legislation on mobility laws, perhaps is quite relevant in the ongoing changes, ongoing needs of a movement of people in the region. Perhaps is very relevant. We look at it that way. And as it has been highlighted earlier, India has fairly a good track record of hosting refugees, not just now, but right from the medieval ages of receiving the Zoroastrians or Jews, or in the recent times, post-independent era of hosting the Tibetans, the Sri Lankans, the Afghan refugees, the Burmese refugees, and so on and so forth. Some of the African refugees as well from Somalia, Sudan, Nigeria, all these countries. So fairly it has, but the numbers are quite small in a way. It roughly, I think, touches something like 200,000 or roughly of that numbers. It's not too high in a way. But there have been debates going on. How do we look at the refugee protection, responsibility sharing mechanism, national interest, national security? These are being, kind of talked. So by and large, India has fairly a good, what Professor Chimney calls it, a good charity approach on the refugees. So now we are looking at how we can bring in the legal-based approach. So that's where I'm emphasizing the need for having a national legislation in the region to address refugee protection, asylum seeking. That's the point I'm trying to bring in. Now we have had discussions on 2-3 critical things within India. One being the Rohingya refugees. And as it has been highlighted earlier by Professor Sinha, that we have taken the matter to the courts. The courts have said that you need balance between national interest and humanitarian protection or refugee protection. So that is where it remains that we should not violate the principle of non-refoulement. Therefore, the Rohingyas will remain in India. We have a contestation on the numbers. The Ministry of Home Affairs of Government of India calls it around 40,000 Rohingyas, where the UNHCR scales it somewhere around 15 to 16,000 Rohingyas who could be, brought into the fold of how many are there and what are their needs, and we can protect them. But as of now, they live in a very, very vulnerable situation, which is a matter of concern. So the humanitarian, diplomacy is also an important tool, perhaps we can have as a part of our national legislation, which can balance our national interests and humanitarian concerns. So already it has been highlighted that India is part of number of human rights instruments, be it UDHR or International Covenant on Civil Political Rights, International Covenant on Economic, Social, Cultural Rights, Child Rights Convention, CEDA, CAT, it has signed but not ratified yet. So anyway, major instruments, it's part of it, which can become very relevant. There are very progressive judicial interventions which are happening, which do provide a framework on which the protection can happen. So therefore, to recap again, that 51 Convention, 67 Protocol, regenerated with the global compacts on refugees and migrants, becomes an important framework in which we need to within the country relook at these issues and see how far we can make a relevant framework to address the vulnerabilities, marginalities, and the access to justice for refugees and asylum seekers. This is my framework submission. Thank you.
Thank you, Dr. Parivelan. Finally, I'd like to turn to Professor Al-Shubaki and get the perspective from Jordan. It's been 10 years to the Syrian refugee crisis, and Jordan hosts a large number of refugees. Many of those refugees are seeking to resettle in a third country. What is their future, and how has Jordan approached this?
Okay, thank you, and good afternoon, everyone. I'm happy to be with you today with this very interesting discussion. Let me address some issues regarding the national and international obligation in addressing refugees' needs in Jordan, and then we can understand the new reality in Jordan regarding managing of refugees. As you know, Jordan is the center of the Middle East, located in the center of the Middle East, and it's bounded by conflicting regional powers such as Iraq, Syria, Palestine, and Israel. Okay, so Jordan received several waves of refugees, including Palestinian refugees, several waves of Iraqi refugees due to the First Gulf War, after depacification, ISIS appearance, and so on. Also, Jordan received a massive influx of Syrian refugees due to civil war in Syria. Focusing on Syrian refugees, the latest wave, we are talking about 1.2 million of Syrians were hosted in Jordan. Only 600,000 of them are registered as refugees by the UNHCR. So we are in front of several waves and several realities of refugees in Jordan. But the question is, what are the international obligations of Jordan toward refugees historically? I can tell you that Jordan is not a signatory of the United Nations General Assembly Resolution 194. Jordan is not a signatory of 1951 Convention or 1967 Protocol, and even the Universal Declaration of Human Rights. The question is why? So also we have different reasons and drivers why Jordanian government is not a signatory, for example, of the United Nations General Assembly Resolution, although it has different pros or advantages. But at that time, when the world started to sign for this significant resolution, the 1948 Arab-Israel conflict didn't stop and until the declaration of the Israeli-Jordan truce in 1949. Also, many countries consider it inclined toward Israel benefit, and also Israel itself did not commit to articles that yield favor for Palestinians and their rights. This one. Also, look into the 1951 convention, this significant convention or landmark in the history of the legal framework of refugees. Jordan does not sign this convention because it doesn't take into taken in the account only very limited range of refugees, and it doesn't cover Muslims and people from other the world. At that time, still the situation of refugees, Palestinian refugees, wasn't clear, and Jordan cast doubt regarding the resettlement of Palestinians, which that could influence their rights in Palestine. Also, which this very significant in case of Jordan as developing country, there was a lack of sufficient support to host the state to implement this convention. So this makes Jordan less interested in signing this convention. But again, that doesn't mean Jordan did not participate on some international obligation, but I would say it's more regional. Mainly, Jordan is a state party of Casablanca Protocol 1965, which is a very significant landmark in the Arab world to address Palestinian refugees movement, rights, the right to work, and so on. Also, Jordan is a signatory or a state party of the 1998 Memorandum of Understanding, which organized the entry of Iraq's refugees, which this Memorandum of Understanding indeed included some principles of the 1951 Convention, but again, it includes the resettlement condition. So Jordan opened its border, settled Iraq's refugees, which later on the civil war of Syria, it's also included Syrian refugees for this memorandum of understanding, just to stay in Jordan 6 months and later on to be resettled in Europe or North America. But still, due to the ferocious of civil war in Syria and the migration crisis in 2015 in Europe, that it's also negatively impacted the sufficient implementation of this memorandum of understanding. And again, the Jordan is a state party of the Arab Charter on Human Rights, and most recently, Jordan is a state party of the Global Compact on Refugees and the Global Compact on Migration, which again, it's non-legally bounded. So we have some also observation regarding these two legal, at least humanitarian instruments, if we want to call it as this. But when we are talking about, does Jordan have like a national refugees law to address this tremendous number of refugees all over the time and from different geographic location? I would say no. And sadly, no, because Jordan only applies law number 24 on 1973 on residence and foreigner affairs. We address the entry of refugees to Jordan from this law, and we consider refugees should obtain a residence permit, and they have to enter Jordan by based on the visa entry conditions, and then they have like a residence permit, and once this residence permit was not renewed, they have to leave the country. So with some international organization collaboration, we have some settlement for this, but indeed refugees in Jordan considered like a foreigner or as a guest, like in the Syrian refugees crisis, the Jordanian government addressed them as a guest. So it's also here an issue. But what is the consequences of applying like foreign affairs law on refugees? Indeed, it put them in a difficult situation, especially regarding healthcare issues, education, and entering the labor market in Jordan. Why? Because according to the labor law number 8, foreign workers cannot be employed without work permit from the Ministry of Labor, including refugees. So even refugees have to work based on work permit and with relatively high fees. So Syrian refugees work with the Jordanian companies or farms or and so on, based on more informal labor market with lack of job security, discrimination, and poor economic or work conditions. It's also that the cost of obtaining a formal work permit put them in a very difficult and fragile conditions, and it's hinder their integration on labor market officially. So due to the like long time span of this issue, and we can say it, the Jordanian government signed like a very popular agreement with the European Union called the Jordan Compact to integrate Syrian refugees into Jordanian labor market, create opportunities, and protect them from informal labor market by issuing work permits for them, but with with waived fees, just to make sure that they formally enter to the labor market and they can be protected from, for example, poor work conditions. Again, the legal vulnerability. This is what I address also with the special issue here. It's like the legal vulnerability of refugees in Jordan, and mainly Syrian refugees, put them in an economic precarity, because once you are considered like as a guest, as a foreigner, you cannot be successfully engaged or integrate on community and labor market and education system and so on. Indeed, Jordan adopts several welfare policies to provide like a shelter, food, and so on, shelter, nutrition, education, employment, and so on. But still, it's like it's completely regulated, and it's influenced by the foreign assistance, by international obligations to some agreement, and it's also it's affected by the economic conditions all over the world. So Jordan, not only Jordan is receiving refugees, but several countries all over the world, and the spillover effect of poor economic condition, the pandemic, and so on, are negatively impacted the welfare of refugees in Jordan.
Thank you,
And
Professor Al-Shubaki.
thank you.
You did outline the fragile conditions and vulnerabilities under which refugees live. And as we have this discussion, there is one aspect that we have to raise, which is the question of statelessness, a question that in South Asia has become very pertinent because of the Rohingya crisis. If I can turn to Anasua and get your perspective on this, and what can be the remedy to the question of statelessness.
Well, thank you, Sunana, again. And I uh, thoroughly enjoyed listening to all the speakers' deliberations. Throughout the deliberations, I have noted several points and occurrence of importance of rule of laws, bill of rights, constitutional governance, securitization of migrants, and also importance of the new New York Declaration, which was adopted in 2016, along with two compacts. If you ask me, Sunana, my main intention was to raise the question of statelessness from the legal perspective when we are dealing with the definition of 1951, relevance of the definition of 1951 against the backdrop of today's, complex globalized world. Uh, we have seen that how often the two words refugee and stateless people, these are being used synonymously, but these two words they have a specific legal connotation, and in this particular volume we intended to raise this legal connotation to understand the precarious situation of stateless people, which is entirely different from the conditions of the refugees. And the best example of stateless people in this part of global south is, nowadays we know that the precarious situation of Rohingyas. So that's why we intended to keep a separate section on stateless people with special reference to Rohingyas, to understand that legal interpretation. if we go back to again the definition of statelessness, we will find that like refugees, we have in international, international field, we have two specific laws dealing with the situation or the conditions of stateless people. One is in 1954, another one is in 1961, and in both these cases, actually, statelessness. Both these cases, statelessness has been specified as a status without nationality and presence of the state. So it is very, very important, and the status of stateless commonly impacts the refugees, uh, although not all refugees are stateless, and not all stateless people may be termed as refugees. And here lies a difference between refugees and stateless people. So far as international legal instruments are concerned, these statelessness can be defined in two ways: de jure stateless and de facto stateless, and they have specific, definition and the specific difference between de jure and de facto. But the main point that we intended to raise in this volume is a critical point of international legal interpretation while we are dealing with statelessness. You know, the great fallacy that we have found through our understanding, great fallacy of international law of statelessness, is that a stateless person is defined by his or her land. Yet, to claim any legal correctives or rights, the stateless person has to cite definite attributes. How can it be, uh, it be related to one's identity? I think it is very, very important when we are raising this issue of lack with their identity. With these words, Sunana, I'll request you to ask our experts about their opinions about on stateless situation in South Asia.
Thank you, Anasua. We could turn to Dr. Sinha, if you can respond to some of what Anasua has just said.
So thank you very much. Anusha already covered everything, and the stateless and two important conventions. She has also 1954 and 1961. And just to mention one thing, in Indian scenario, we have a couple of scenario of statelessness. Particularly, one is related with the Chakma refugees, and a case was filed in the Supreme Court of India by the another statutory bodies, National Human Rights Commission. See, the problem here, this so that you have to see according to the Citizenship Act of the respective country, statelessness. So according to and that is the reason, we have amended our Citizenship Act in the 1986. So it's become little bit stringent. So so only the persons who have entered in the India legally, there, any birth takes place in India, they are entitled to become. So status of parents become very important, and that has created little bit problem. But this amendment has taken place in 1986. From 1950 to 1986, things were more normal. But still, when it so whether you have entered legally or illegally, everybody were entitled to become Indian citizen after spending stipulated time of 11 years, and then you apply for that. And in India, and I believe in the other South Asian countries also, even we have more or less a federal structure, but it's decided by the union government. Central government plays very important role on the citizenship. And all application has to be processed from the local state government to the central government. So entire process, and some way the case which was filed in the Supreme Court of India regarding the citizenship issue or regarding the statelessness of Chakma refugees, what happened that they were fit according to the Citizenship Amendment Act, according to this unamended Citizenship Act 1955. But still, and they were third generation, not the first generation. They were second generation, third generation. They are like, no. So according to the Citizenship Act, they should have given the citizens like an act. But local politics prevented the local government, the state government, and their applications were never processed. So statelessness is a status. And if we see the entire development of international refugee law also started to address the statelessness with the Nansen passport in the 1922, when all of a sudden the Bolshevik government, like, after Bolshevik revolution, a decree was issued that those who have left the Russia, they have become statelessness. And that was to address that situation in 19. So that is like, that process. And unfortunately, both convention, very few states are parties. So both 19 stateless concerns. So there is just some kind of total disregard for the not only India, a large number of states regarding the stateless, like 1951, 1954 convention and 1961 convention. So ultimately, it comes down to the state. So, but of course, like, we have to, like, address the statelessness person, and each state should take initiative. I believe it has to be reformed at the local level, and the state government has to take whatever way we like, people should be given the citizenship, or whatever the condition has to be laid down. It has to be reformed at the national level. And of course, like, UNHCR and other relevant bodies, NGOs can also play very important.
Thank you, Dr. Sinha. We actually are running out of time, and I'd really like to bring in all of our speakers. And we've had some fascinating insights during this conversation. Emily, if I can turn to you and go back to the question of securitization, is there a way to balance, perhaps, or find areas of convergence between state security on one hand and human security on the other? Have you seen any country which has implemented that?
Thank you, Sunaina. I think that's sort of a key question that sort of within European debates we're really looking at in terms of rhetoric as well as policy. And I would say from the European standpoint, these are countries that have ratified the Refugee Convention and generally have both the financial means as well as the institutional means to host the small numbers of refugees who do make it to Europe. So in the European context, specifically, what we see is really a disconnect between national security debates and the realistic domestic asylum environment that we see in many European countries. I think what's going to be key in order to shift the debate more from national security in Europe specifically to human security is really the integration of asylum at a more supranational level, moving away from an intergovernmental system that can really focus on responsibility sharing across European states. I think particularly the crisis in Ukraine is something we're going to have to watch very carefully as well, to see if it can sort of be a catalyst for a more common approach to asylum that can then trickle to other areas in Europe and move the debate more towards human security. So I think my response to your question would really be, I think there are worrying trends in Europe, but specifically, I think the means are there. It's a question of translating the political will domestically, as well as improving relations internationally with neighboring countries that continue to be very Eurocentric and security-driven when they shouldn't be.
You just talked about responsibility sharing across European states. Professor Mupedi, is that something that Africa is looking at all?
Thank you. Definitely, the issue of responsibility sharing is a critical one, but I wouldn't say things are moving at the fast pace that would require. If you look at the different regions, the sharing of the load is unequal. Obviously, Southern Africa, is at the bottom of the continent, but you look at the Horn of Africa, Eastern, this is where you also get more refugees. Obviously, it also depends on what are the hotspots, where the problems are. But I think African countries can play an important role not necessarily because of their geographic location in terms of, how far the refugees can travel, but to come together and support each other, working closely with the relevant UN agencies to ensure that the right support is provided. For me, I think what is also critical is to prevent certain man-made situations that are known and can be avoidable, especially, civil strife, civil wars, and all those things, because that would be the starting point.
Thank you. Dr. Parivalan, you have looked quite closely at the question of Tamil refugees uh, from Sri Lanka in India. Can you shed some light on that?
Yeah, sure. Thank you. Yeah, it's very important to see how India has, hosted the Sri Lankan refugees right from 1983-84. A civil war which emerged in Sri Lanka. It was a very humanitarian gesture that India had, hosted. It also had a trajectory that when post Rajiv Gandhi assassination happened, that there was also a push factor at the time where they wanted to forcefully return some of the refugees. Then this principle of non-refoulement got established by some very prominent court cases, Nedumaran and Ramadas versus Government of India. And therefore, then India obliged that it will follow this principle. And therefore now, they have been living here, war is over. So what are the, kind of needs, evolution of the people? We did an assessment in 2014. And we had seen that nearly about 68% of the people, refugees here, which is nearly about 100,000, 58,000 or so in the camps, and remaining 35,000 outside the camps. So it constitutes roughly about 90,000, 100,000. So they felt that 68,000 are not willing to return. That's the kind of a thing we got. We were very surprised after a war why they are not willing to return. That brings it to question that the situation of militarization in Sri Lanka, the lack of addressing the core minority concerns within Sri Lankan governance polity, and an ongoing authoritarian regime now with economic crisis in the recent times, all culminates where people look at that if they return, what are their livelihood options, what are the restoration of the rights. These all dampens, and then they're exploring the possibility that if they lived here for 20, 30 years, that whether they can explore the opportunities of getting assimilated, local assimilation or citizenship. That is also a trend going on. Now, government of Tamil Nadu has constituted an advisory committee where fortunately I have an opportunity to be part of it. And we are trying to look at two levels. One, to look at their immediate needs, such as housing, repairs, toilets, livelihoods, and immediate needs. And the longer term needs, we are seeing that whether they will be able to repatriate, whether there will be any facilitation from, as a coordination between Government of India and Government of Sri Lanka. That's an option which some of them may show interest. And some of them, it looks like will also want to opt to remain in India. Here, one important concern comes in, which is emerging. We are trying to, address it. Is that half of the population refugees here seem to have some kind of an Indian connection. They are not typically Sri Lankan Tamils, but Indian origin Tamils who had gone as a plantation workers during the British, indentured labor, which took place. Therefore, these people have signed, some of them, the 1964 pact between India and Sri Lanka called the Sri Mava Bandaranaike and Sastri Pact earlier, and Indira Gandhi Sri Mava Pact. Part of the pact, some of them wanted to come back to India, but they missed the bus and then later got engulfed in the civil war. Therefore, they have every right to claim their citizenship, but Government of India had not done so. So we are pushing it that we should map these people and address their unique concerns and look at the larger level where we do. There is a lot of positive thing which is emerging from the state government. But we all know that the mandate is with the central union government. Therefore, there has to be a proper dialogue, address the issues, unique nature of needs of the Sri Lankan Tamil refugees and Malayalam Tamils, otherwise called the Indian origin Tamils. Then there could be a good model of addressing their durable solutions by and large, and it can become a very good case example where I'll just add on one last point. Then we are talking about legislation and things like that. I think India has done fairly good amount of refugee protection, which has not been recognized, which has not been documented. I think it's time that it's documented, all the good practices and lessons learned that can probably feed into the better refugee policy and governance. Thank you.
Absolutely, and the positive example that you shared is perhaps something that all countries could be learning from. Professor Chubaki, Dr. Parivalan had just raised the question of assimilation of refugees. Is that something that Jordan is working on? You're on mute.
Sorry. I was saying, when we consider like the social and cultural context of Syrian refugees or Palestinian or Iraqis, the Jordanian government has no intention to assimilate them. Why? Because we already have shared values, customs, language. So integrated them is a solution for the government to make them like effective residents at least. But there's culturally we are similar. We speak the same language, the tradition, values, again. Religion, most of them, even Syrian refugees, most of them are Arab, Sunnis, very similar to Jordanian community and social values. From different sides, when we talk about integrate them is way easier to the Jordanian government, especially we are not talking about any chance for Syrian refugees or other refugees for naturalization process in Jordan, so are not going to naturalize them based on the constitution and based on the Jordanian laws. So make the assimilation something is inapplicable in Jordan. I would say that. Yeah, I would say that it's not, it's unapplicable due to the similarities, due to the political and social context of refugees in Jordan.
Thank you. We actually have just a few minutes left. If there's anyone who would like to come in, then please do. Yes.
Can I just come in, add on to what Dr. Anasua Basure had raised earlier about statelessness and what Professor Sinha had also, supplemented. I just wanted to add, in an Indian context, I think, we have looked at this issue for a very long. And India, 1955, Citizenship Act is a very rigid act, but some amount of amendments have happened. Now, I would like to flag here two things. One, the National Register of Citizens in Assam experimentation and the CAA, Citizenship Amendment Act. I think both 2019, both are, I think, quite become very volatile in India. The NRC process has directly led to nearly 20 lakh people, that's 2 million people, formally been excluded. So what is the way forward when government of Bangladesh is saying that they will not admit any one of them, when India says that they do not belong here? Now there's a question of documentation, question of documents, question of submission of documents, and then there's a kind of a very clear othering process which has happened. Number one. Number two, similarly, you have every corner of India being very connected in South Asia, culture, and other things interconnected, and the incongruity between the culture and politics brings in a lot of displaced population who are invisible. I think we need to probably address them. I hinted a little bit within the Sri Lankan refugees, you have potentially stateless people from the Indian origin nature. I just flagged it, but we need to conduct a mapping exercise and bring it out. Similarly, there are invisible, marginalized populations which may face statelessness. Probably, I think it's high time India takes it a priority in line with what UNHCR calls it an I Belong campaign of ending statelessness globally by 2024. Let's endeavor it as a democracy, as a country which believes in rights. We should strive for it. This is an additional point I thought I would.
That's a wonderful note to conclude on. And as had come up in our discussion, the question of human rights, of displacement, will remain extremely relevant. And we have a sobering reminder of that today with the situation in Ukraine. Thank you very much for taking out your valuable time for this discussion. You've left us with a lot of food for thought. And I'm sure that we at ORF and each of you in your own capacity will be building further on these discussions. Thank you.
Thank you very much.
Thank you.
Thank you so much, Sunana.
Thank you so much.
Thank you so much.
Thank you, everyone.
Thank you.